One text can violate a no contact order. Don't risk it. So you picked up a domestic battery charge. It's in Johnson County. Where are you at? What can you expect? Well, as soon as you're charged, no contact order is going to be put in place. Whoever you're alleged to have battered, to have hit, whatever the circumstances, you cannot have contact with them. But you might not also be able to have contact with other people. Common, we see spouses. Maybe husband hits wife, wife hits husband, whatever it may be. And the spouse that gets hit, there's a no contact order. You're not allowed to have contact with that spouse that gets hit. But guess what? Let's say you have 3 kids. You're not going to be able to have contact with those 3 kids either, especially not if they were in the home at the time. So what conditions might you have after release? And in Johnson County, I'm telling you, anyone that was there, there's got to be a no contact order, and you do not want to violate it. Then the question becomes, no contact order, what does that mean? What if I just text them and I don't go see them, or I send them a letter, but I'm not calling them? No, you don't text them, you don't email them, you don't call them, you don't go take a walk by their house, you don't say hi to them if you see them in a grocery store, you don't send them a poke on Facebook, nothing. You do not have contact. If they call you on the phone, you don't answer that call. That's what it means when there's a no contact order. Because when there is a no contact order, any contact at all can cause you to violate. And that can be really, really bad for your case, because even one tie is a new charge, what we call an invasion of privacy. It's a misdemeanor. But unlike almost any other charge in the state of Indiana, they can stack. So if you text her, and then the next day you text your wife, and then the next day you text your wife, guess what? That's 3 different invasion of privacy charges that you could pick up, and all 3 can be a year in jail, and they stack. So now, let's say this was a level 6 felony domestic battery because a child was there, right? And you were looking at up to 2.5 years in jail. Well, now you're looking at up to 5.5 years in jail, all because you sent 3 texts. Don't do it, right? Same with when there is a no contact order. That means that if you're married, for example, and you live in the home, you're not going back to that home. You're staying somewhere else. I don't care if it's a hotel room. I don't care if it's with friends and family. It doesn't matter to me. And as your attorney, you can talk to me about it. I can certainly make recommendations. I can try to help you out. But what's key is you cannot be at that home. So make sure that you're not. And I understand it can be very difficult sometimes, especially with married couples or especially with people that have kids. And they're like, well, if I can't have contact, like I've got bills to pay, they've got this and that. I get it. It can be really difficult. You can't have contact. Don't risk it. It makes it harder for you because you're setting yourself up for more jail time potentially. And it also makes it harder for me if I'm trying to negotiate and say, hey, look, my client's a good person. Give them a break. They violated the no contact order 50 times. Don't do it. So what evidence might we look for in domestic battery? Well, always we're going to look for injuries or lack of injuries. And in Indiana, what you have to understand is there doesn't have to be injury. When we're talking about battery, pain is enough. So if I'm mad at you and I hit you that hard and you say, ow, that can be enough to support a criminal conviction. So there doesn't necessarily have to be injuries, but we are going to look for that, because if someone's saying you punched them in the face 50 times, logic dictates there's got to be injury there. So that's something we're going to be looking for. We're going to look at the context. Okay, well, they're saying this happened. So let's say they swung first and then you swung at them. Well, now maybe the context could be self-defense. Maybe that's an argument we make. Are there any statements? Were there any other people there that saw this? Did they give conflicting statements? Are they all saying what the victim initially said? Also, the 911 call. What's said on the 911 call? Who called 911? These can all be important things that we need to look at from an evidentiary standpoint. So what things can they're done for mitigation? Well, first, there's something called the Domestic Batters Program. Johnson County has it. So we might get you in that. Let's say we're like, hey, look, there are some witnesses. You got mad, you got drunk, maybe you have a mental health issue, maybe you have a drinking problem, and that set you off. And then you did hit someone, you hit your spouse. What can we do to set you up? Best case. Well, maybe we need to get you into mental health counseling. Maybe the reason that you're doing this leads back to a mental health issue. Maybe we need to get you in a batterers intervention program. Maybe we need to get you into an alcohol treatment, right? Because maybe alcohol is what seems to set you off. These are all things that we might be able to do. You could take steps, show that you're trying to better yourself. That's going to be a way to mitigate you to the prosecutor. As far as parenting, that could be really difficult because oftentimes when there's a no contact order and you have shared kids, you're not going to be able to have contact with those kids. But sometimes we can do things. Maybe you can see the kids sometimes if they're at grandma's. Maybe we can set that up. There can be different ways that we might be able to set that up. But it's important that when that no contact order is in place, one of the biggest ways you can mitigate is to just not violate the no contact order. Just follow it. Stable housing, things like that can also be ways that we mitigate. Maybe the issue is that you didn't have a good home environment. You didn't have good living conditions. And that was what set you off. How can we get that to be better? And so these are all things that we need to think about for mitigation. So specific to Johnson County, things like how violations are treated can be very important. Because I'm telling you right now, Johnson County has has specific prosecutors that are handling these domestics, especially these felony domestics. And I'm telling you right now, when they see you violated, they will use that violation. They see you violate that no contact order, they're gonna absolutely hammer you. And additionally, if they give you a nice plea, they say, hey, look, I'm gonna give you one chance here. I'm gonna give you just probation. And you violate that probation in some way, they are going to be looking for jail. And so how to negotiate with them, how to set you up can be really important. So if you pick up a domestic battery case or a battery case in Johnson County, it can be really important to have an attorney that understands how to fight domestic violence cases, but also how to work with Johnson County prosecutors, how specifically they need to make arguments in Johnson County to set you up for success. So if you did pick up those charges, you're in Johnson County, call the Marc Lopez Law Firm at 317-632-3642. And remember, always plead the fifth.